Someone in your life wisely drafted a financial power of attorney so that if their health declined and they were not physically or cognitively able to manage their own financial and legal affairs, they've named you to do it for them. Great. But now you're running into a roadblock because the bank or the investment firm is not honoring your power of attorney. They want you to fill out forms or show proof that your loved one is incapacitated. We see this all the time. It does happen. Let me tell you what's going on. My name is Patrick Cawley. I'm an elder law attorney with Keystone Elder Law in Mechanicsburg, Pennsylvania. I'll tell you about someone I was just dealing with recently. We'll call her Jane. Jane was named as the power of attorney agent for her aunt and her uncle, both of whom have dementia. They're in a nursing facility. Jane's trying to get their bills paid, trying to manage financial affairs to get them eligible for Medicaid to pay for long-term care. But talking to one of the well-known investment firms, she was told, we need you to fill out this form, we need you to prove that your aunt and uncle are in fact incapacitated, and so forth. Now keep in mind, every day in a skilled nursing facility costs a lot of money when Medicaid's not paying the bill. So every day that passes with the bank pushing back is going to cost the family money. Here's the law in Pennsylvania. Pennsylvania says, if you have a valid power of attorney, the financial institution must accept it. End of story. So Jane goes in, she shows her ID, she says, look, this is a valid legal document, it's still in effect. I'm the person, so allow me to stand in the shoes of my aunt or uncle and transact business with you. The only wiggle room that the financial institution has is if, one, they have actual knowledge that there is a more recent power of attorney that revoked the one that Jane's showing them, but that wasn't the case with the person I'm dealing with. Or if they suspect elder financial exploitation. Elder abuse is widespread and these financial institutions are on the front lines. So if they suspect it, maybe they can ask for some more proof, but that security comes at a cost for the family. So that if the attorney who drafted the power of attorney document writes a letter to the bank or the investment firm and says, look, this form is still in effect and you must honor it, or every day you're going to be liable for the costs that this family is incurring in long-term care, normally that will solve the issue. But I just want you to know that they might have their own financial power of attorney form. They might have their own agent authorization form. It goes by different names, but you can fill it out if it's going to make the problem go away quickly, but the law says that they must accept a valid power of attorney. And if you have to get your attorney involved to certify that it's legitimate, then do that as quickly as possible, because otherwise it could cost your family a lot of money. And by the way, if you're thinking, well, if the banks have their own forms like this, why do I need to go to an attorney for a power of attorney document? Keep in mind, what the bank has is just limited to dealing with that bank. They don't want to be stuck with an incapacitated account holder and they don't know what to do with the money. They want business to keep flowing. And so that form allows them to allow someone else to transact business on behalf of the account holder, even when there's an incapacity issue. But that account holder, if that's all they have nothing to allow someone else to work on their behalf with other institutions, to sign legal agreements. In other words, a general power of attorney that will address far more than just the account at that bank. If you have any questions about being a power of attorney agent, having someone represent you in a power of attorney, shoot me an email at info@keystoneelderlaw.com. That's info@keystoneelderlaw.com, and we'll talk you through it, explain the concepts to you.